Right, you may open this time out.
Good morning, all rise. The 36th District Court in the state of Michigan is now in session with the Honorable Judge Donald Coleman presiding. While court is in session, there will be no eating, sleeping, talking, gum chewing, or arms resting on the bench. If you have a cell phone, put it on silent.
Thank you, and parties on the, I'm not calling you forward yet, but parties on the bench trial, you ready to proceed? Are you still in some processes? What's going on?
Ready to proceed, Your Honor?
All right, calling you short. All right, this is case number 24171453. This is Rodney Chiropractic versus State Farm Mutual. The matter is before the court. Set on for a pretrial hearing. Your appearance for Rodney, please.
Your Honor, I apologize. This is Dree, Mr. Fortner's assistant. He should be logging on shortly. He was just wrapping up another hearing.
All right, thank you, ma'am. Do I have counsel for State Farm? For State Farm, please. All right, we'll come back to that matter momentarily. All right, this is case number 24-24-0-943. This is Arthur Jenkins versus Ashley Johnson. The matter is before the court regarding the filing of a subpoena, and subsequently directed an application for subpoena in this matter. All right, do I have Arthur Jenkins in this matter? If you're on the Zoom, please say something at this time. Arthur Jenkins. Well, Arthur Jenkins. Madam Clerk, you heard anything from Mr. Jenkins today? All right, it appears then that the defendant directed that plaintiff did not appear regarding the application for subpoena at this time, and on the failure to appear, the subpoena will be quashed at this time.
Ms. Johnson is on there.
As the respondent, right? All right, do I have Ashley Johnson?
Yes.
All right, good morning to you, Ms. Johnson. Ms. Johnson, have you had any contact with Mr. Jenkins relative to resolving this matter, or have the two of you found a way forward?
No, I haven't had any contact with Mr. Jenkins.
Okay, very well. All right, well, I'm dismissing the subpoena at this time. And basically what he indicates that he's seeking is some information from you so that he can go forward and collect on this judgment. That information would involve your social security number and other information. I see that the judgment here was entered. Just one moment here, ma'am. Yeah, the judgment was entered on the 17th of September of 2024. The judgment was $351. You might want to try and find some ways to get that resolved, ma'am. Otherwise, it's going to keep coming up. You have to give up your social security number and all kinds of personal information over $351. But at this point, the subpoena is dismissed because the petition is not here. The case is not dismissed, just a subpoena for your information.
So how do I go about getting it resolved? Because we don't have contact with each other. I'm in the process of filing a PPO because him and his family threatened to kill my family, and it's also another case going on for assault from him and his family.
And none of that has anything to do with this financial matter.
Right.
But this is what I'm going to have you to do, ma'am. I'm going to have you to come back in on Thursday, the day after tomorrow. Once you come back, I'm going to recall this matter, and I'll talk with you then about some things that you might be able to do to at least get this part wrapped up. You understand?
At what time Thursday?
Yeah, at 9:30 on this coming Thursday. That is Thursday, the 1st of May.
Thursday, May 1st. Okay, come back to this meeting.
Yes, ma'am. And then I will have your file, and we'll go over some things that you can do to try to get this closed out. Okay.
Okay.
All right, I wish you well, members. See you on Thursday. Court now calls case number 25-42089. This is Grand Transportation Services LLC versus AAA Insurance. The matter is before the court, set for I think this is a pretrial conference. Let's see, one moment. This is a status conference, first hearing regarding this matter. I understand that this is a case with Mr. Fortner as the attorney on this matter. Do I have counsel for AAA on this matter? All right, I'll come back to that matter, Dan. I don't see where I have counsel for AAA at this time, and Mr. Fortner is in another court. This is case number 25-142484. This is LBNB Funding versus Maurice Mucker. The matter is before the court, set on for its first hearing. This is a scheduling status conference, I should indicate. Do I have an appearance from LBNB Funding, please? All right, Madam Counsel, Madam Officer, Madam Clerk, I'm sorry.
Yes, Mr. Loser was here.
Okay,
I'm not sure.
so we're awaiting his return on this matter. Do I have Maurice Mucker on this Zoom? Mr. Mucker? No response should be indicated. Court.
Mr. Mucker was there, Judge. I don't know.
What's?
They was talking,
Oh,
but I'm not sure. They did go in the breakout room. I don't know what happened to him. He was there.
I do see that there is a device that is yet in the breakout room. I don't see Mr. Rusin there. Let's see if it might be Mr. Mucker. All right, do I have Mr. Mucker on the Zoom? Maurice Mucker? Mr. Mucker? Hit *6 if you're on mute. Do I have Mr. Mucker? Are you Maurice Mucker?
Yes, I am.
All right, thank you, sir. I called this matter. I'm waiting on Mr. Grusin to come back into the courtroom regarding this case. So just sit tight. I'll come back to you, sir. All right, this is case number 25-142570. This is Portfolio Recovery Associates versus Eric Simmons. The matter is before the court, set on for a status conference. This is the first hearing regarding this matter. Do I have someone from Portfolio? From Portfolio? Do I have Eric Simmons? You had any information on this?
No, that was that.
All right, neither party has appeared regarding this matter. I'm seeing that a notice was sent out on this matter on the 26th of February, 2025. There have been no requests for adjournment or anything along that line. Madam Clerk, dismissal. That's been a couple of months before the hearing. So I'll dismiss the matter this time without prejudice. All right, the court now calls case number 22-190602. This is Jordan Irby versus, is that the matter that's here? No. Versus Dennis Coleman?
Yes, I'm here.
All right, thank you. Who are you?
I am Dennis Tillame.
All right, thank you, Mr. Tomei. All right, the matter is before the court on a petition and order to show cause. And well, actually, I have it here for a show cause on today's date. All right, so what's happened in this case? Have you gotten your financial issue resolved with Mr. Irby?
Yes, I have been making a couple payments. Right now, I'm 2 payments behind with them. But I have been paying them. So, I guess we're on a mutual ground.
Oh, yeah. So what I did in this case, I remember now, I adjourned the show cause in light of the fact that the parties were working on payments, correct? That's what happened, right?
Yes, sir.
So when is your next payment due?
My next payment due, I think we agreed on the 26th every month. So the 26th of next month.
All right, did you make the 26th of this month payment?
No, sir.
All right, so, well, I'm gonna issue another, a notice to see if the other side come here, but you look forward to making that payment or making the payment sooner than that.
Yes, sir.
I'm gonna set a date now. Let's say that on the 27th, Madam Clerk?
27th of May.
Yes.
Yes.
All right, so I'm gonna set you for May 27th at 10 o'clock a.m. You go ahead and make sure you make that payment, because I don't want you to see me on the 27th and you 2 payments behind, you understand?
Yes, sir.
10 o'clock a.m., May 27th, all right?
All right.
All right, thank you. And make sure we send out a form notice so that the notice. I am on the record regarding 25-142-484. This is LVME funding versus Maurice Mucker. The matter is before the court, set on for a status conference. Your appearance for the plaintiff in this matter, please.
Judge, may it please the court, I am attorney Richard Drusen. I am the attorney of record for the plaintiff. My bar number 35222.
Thank you, Mr. Rosen. Good morning to you. I know that you and Mr. Mucker, Mr. Mucker indicated his presence earlier when I called him that. I know that you did. Yeah, update me, sir.
Judge, I can tell you that the parties have agreed to enter into a consent judgment. Judge, the amount of the consent judgment will be the amount of the complaint, which is $637.87, consisting of a assigned debt credit card. The original creditor was Credit One Bank. Furthermore, Your Honor, I explained to Mr. Mucker that there were taxable costs consisting of a $55 summons filing fee, a $64.60 summons service fee, total cost, Your Honor, of $119.60. I explained to Mr. Mucker that the state of Michigan concurrently grants with the entry of consent judgments a $75 statutory attorney fee. The total consent judgment, Your Honor, will be in the amount of $832.47. And concurrent with the entry of the consent judgment, there will be an agreed $50 monthly installment order beginning June 10, 2025. And as explained to Mr. Mucker, that before I rest on your record, Your Honor, I now ask Mr. Mucker's permission to sign his name to the proposed consent judgment so that I can file that with the clerk's office. With that, I rest.
Right, Mr. Mucker, I know you had the opportunity to talk about this matter earlier. My understanding now is that there is an agreement for entry of a judgment at $832.47. With an agreement further that beginning on 6/10/25, that $50 will be paid and $50 per month until that amount is satisfied. Is that in fact the agreement that you entered into, sir?
Yes, sir.
And Mr. Mucker, given that this is on the record, and I have the terms written down, are you in agreement with your name being placed on this document as your consent regarding this matter?
Yes, sir.
All right, very well. I will find the matter that the matter has been resolved, and Mr. Rusin, you may submit the judgment accordingly, and Mr. Mucker, as soon as that judgment is entered, we'll make sure that you get a copy of it as well.
Thank you, Judge. With that, I rest.
Good day to both sides.
Thank you.
All right, and ma'am, at Mr. Fortner's office, any citing of Mr. Fortner, please? And Madam Clerk, you indicated that on the AAA matter or one of these matters that there was counsel on this matter?
Except for the AAA one, no. No one signed in on that night.
State Farm?
No, they haven't signed in. State Farm hasn't signed in or AAA.
All right, the record should reflect that the court did issue a notice with regard to the subjects 1453, that's Rodney versus State Farm. That notice was issued on 2/26/25, setting today's date for the hearing. I do see some exchange of documents as between the parties, but it does appear that the defendant has not appeared. Mr. Fortner's office has indicated that he's in the courtroom and is intending to appear. Likewise, with regard to the subjects 2089, that's Grand Transportation versus AAA. There seems to have been some exchanges between the parties. I also see a notation. April the 8th of 2025, plaintiffs offered to stipulate to enter to the judgment. All right, I don't see an agreement with that stipulation. All right, so for some reason, the attorneys on the defense attorneys on these matters have not appeared. Certainly, my experience in regard to AAA as well as State Farm is that they would have someone present. So I'm going to reset both of these matters, giving them a new date, and Mr. Fortner will be apprised of that as well. So we're going to set these over. Can we do it the 20th of May, Madam Clerk?
Yes.
Both matters we set over for May 20th, 9:30 a.m. And they are reset for a status conference. That is the stage where the matters are at this time. Mr. Mucker, all set, sir. You can disconnect.
Okay, thanks a lot.
A person from Mr. Fortner's office, if you're still there.
Yes, sir.
All right, you get back. Did you get the information that I'm resetting both of those matters for the 20th of May? A notice will go out in that regard. The defendant's attorneys were not present, and that's kind of unusual. So I certainly reset the date regarding these matters.
Both at on May 20th at the same time?
9:30 a.m.
9:30. Thank you, sir.
Thank you. You got some tissue over there. All right, the court now calls case number 24-160-681. This is Luminaire Electrical Corporation versus Christopher Jackson and Penelope. Last name Jackson, it's a hyphenated name. I would mess it first, but I'm so please forgive me. All right. And today's date time set for a bench trial regarding this matter. The matter is before the court on the claim of alleged damages in the amount of $6,000. All right, your appearance for the plaintiff in this matter, please.
May it please the court, Matthew Norris, P 36806.
All right, thank you, Mr. Norris, and good morning to you, sir.
Good morning.
For the defendant in this matter, your appearance, please.
Jake Khan,
All right, thank you, Mr. Khan. Go ahead with the key number, Mr. Khan.
81817.
Madam Court Reporter, are you able to hear?
If you could repeat it, P number again, Mr. Khan.
81817.
All right, so Mr. Khan is the one that to make sure that you kind of keep your voice up because she's you were one that I thought that she wasn't picking up as well. All right, so plaintiff, tell me where we are regarding this matter. I think when I asked earlier off the record, parties indicated that they were at a place where they're simply ready to go forward with the trial. Sir.
I do think we're ready to go for trial, Your Honor. I have 9 exhibits I've shown to the counsel, and he has, I believe, 6 exhibits he's shown me.
I didn't hear the last part. You said you have 9 exhibits and
he has 6 exhibits.
he has 6. Sorry.
8, sorry.
Hey, but I don't think we really are objecting to each other's exhibits. We've seen most of these documents.
Yeah, you anticipated my next question.
Yeah.
Seems that there are no objections to the exhibits. Do you have them marked already or individually and packaged or something? Counsel?
I do, Your Honor.
And likewise.
I can pull them and mark them. I have them tabbed. I have 4 copies of everything.
All right, perfect. All right. So preliminarily, I suspect that there is a neutral motion for admission of the exhibits without objection. Is that correct, plaintiff counsel?
Correct, Your Honor. Move for admission of both sets of exhibits.
All right. And you concur?
Yes.
All right. The court will admit that the exhibits are admitted accordingly as we move forward towards the trial. Is that any preliminary matters at this time?
I get along famously with counsel. We've discussed the case at length. I think we're ready to go forward.
All right. Those are the famous last words. I get along, but I know that when you say that, that's a truthful thing. All we ask for, of course, is collegiality, and I'm sure that is operation. All right, counsel, Mr. Khan, any preliminary matters, sir?
No, Your Honor.
All right, then you may proceed. Then at this time, counsel, Mr. Norris, with your opening statement regarding this matter.
Thank you.
Well, actually, just one moment before we do that, let's go off the record for just a moment. And let me have both of you gentlemen come this way for just a moment. Mr. Khan, you can finish that out.
Just for this type. know you have to go get my lunch in the thing. So I ain't going to get. Who's your brother? Oh, no. Yeah. Touch.
You know, I forgot to. What? I
Water.
always had it with me, dog.
You want some bottles of water? A cup of water?
You got some, you say you got a bottle of water? Or it's-
I mean, some cups. I think, I don't know, Joyce might have a bottle of water down there. You want me to
Ask her, yeah,
Yeah.
my good friend.
Yeah. Hey, the judge said it to be good for you want a bottle of water. All right, thank you.
All right, thank you, gentlemen. And you take as much time as you need to. Appreciate you, Steph.
Okay. Oh, worse. Rows lying. So why don't you put those little beginning of these first ones that very good first year and say, there you come on, you've seen it. Yeah.
Your Honor, we've been unable to settle the matter, so we'd like to proceed.
All right, let's proceed then. All right, you may, when you're ready, you may proceed.
Thank you, Your Honor. Plaintiff Luminaire Electrical Contractor
Just
Services.
to your voice up, my court reporter is remote. I do, it is being reported otherwise, but can you voice up? Go ahead, sir.
I'll be real loud if I do my best.
Thank you.
Contract with defendant in 2023, begun by an estimate, including hourly figures and some materials. It's a house on Hamilton in the city of Detroit. Scope of the work increased after the permits were pulled in August of 23. The exhibits will show that much additional work was required in October of 2023, and then the parties had a falling out. But October 11, the parties exchanged emails, at which time the plaintiff said, look, we're going to stop. This is a great big house with a lot of electrical renovation required, but if you don't like us, we'll just terminate the permit at this point and send you a bill. They sent the bill, they terminated the permit. They got final inspection October 17th from the city of Detroit. Again in 2023, they only received part payment. Part they did not receive was $5,912. We have exhibits A through I. Thank you.
Thank you, counsel. All right, Ian, court defense, you wish to make your opening statement at this time, sir?
Yes, Your Honor. The defendant purchased the property on Hamilton, Detroit, and originally engaged a general contractor that she discovered did not hold permits for the mechanical or electrical scope of work.
I do need you a little bit louder.
You hear me better?
That's not a microphone, so you know, that's just picking up the recording. Just to hear you a little bit better, I do have a live court reporter, but she's remote. So if you keep your voice up a little bit more, I can be assured that we'll be able to you.
I will do my best to yell. The defendant bought a house on Hamilton, Detroit. Soon after, it engaged a general contractor, which she subsequently had learned was not following the requisite mechanical and electrical permits for the renovations taking place on the property. Ms. Jackson and that contractor had split ways. That was when she had met with Luminaire and had impressed upon them the importance of permitted work. And she proceeded to engage Luminaire based on the estimate that was provided to her. During the performance of the work that they had done, which was ultimately not completed, there was inspections taking place at the property. However, the defendant came to learn that those were not official City of Detroit inspections that were taking place. Apparently, a City of Detroit inspector, Harold Howell, freelances on the side and does inspections. There's no record of the City of Detroit of those inspections taking place as the date alleged. There's questionable reports that were generated to create additional work for Luminaire to do on the project. Once that came to light, the defendant was told if she were to have the pockets of that inspector, she would get approvals. She that's not what she was interested in. This is a 1930 home. She cared more about the safety of her husband, their dogs, and that led to the breakdown of the relationship with Luminaire. Ultimately, she was able to hire a subsequent contractor, hold a permit, called in an inspection to document the violations that were in the electrical work at that time, and subsequently spent $20,000 on that contractor to correct and finish the scope of work. The defendant denies that there's any additional money due. When an invoice was provided to her, she had made the payment of over $16,000 in the attempt to resolve the dispute entirely. And it was 7-8 months before she got wind that the lawsuit in this case had been filed.
I didn't hear the last part. It was 7 or 8 months.
It was January 2024 when the payment was made, and it was 7-8 months later when she found out she was the defendant in the lawsuit for the remaining balance that she had disputed previously. So we stand here today disputing the debt this time.
Thank you, Counsel. Counsel, your exhibits, have you numbered them?
No, they're numbered 1 through 8, and I have pulled if the court wants copies of them. I can.
And I will be receiving copies in a moment. And so the plaintiffs are A through I, and then the defendants are 1 through 8 for the record. All right. All right, you may proceed at this time, Council.
Your Honor, plaintiff calls Davy Jackson. Your Honor, may I approach the clerk with exhibits?
Sir, just stand for just a moment, raise your hand, and sworn. And state your name.
Damian Jackson. Damian Jackson.
Damian Jackson?
Yes.
Is that right?
Yes, sir.
All right, thank you, Mr. Jackson. You do solemnly swear or affirm.
Yes.
Speak loud. You do solemnly swear or affirm testimony you're about to give is the truth, nothing but the truth, so help you God.
Yes, sir.
All right, thank you, Mr. Jackson. You may be seated.
Also, sir, real loud, please. State your name and address.
Damian Jackson, 25901 West Tamar Road, Suite 222,
Where are you employed?
Coleman Electrical,
How long have you been employed by Luminaire?
2006.
Are you also the owner?
Yes,
And you've been the owner since 2006?
yes,
Is Luminaire a licensed electrical contractor?
yes, it is.
You're familiar with the dispute which we're here about today, are you not?
Yes, it is.
Your Honor, may I approach the witness? Show you what's been marked as Exhibit A.
Yes.
Other papers. What is Exhibit A, sir?
So that's it.
1477 in the upper right-hand corner, is that correct?
Yes.
When was that estimate started or begun?
Looks like the date was 6/23/2023.
And does that estimate prepare in the ordinary course of your business?
Yes.
And what's the scope of the work on the 1477 Exhibit A?
The scope of the work is to complete unfinished electrical that was done from the previous contractor, which the walls was closed up. We were supposed to finish, she gave us the outline of certain things that needed to be completed, which we walked the house and picked out certain things that needed to be completed. I explained to her that we had 80 hours. We would do it within 2 weeks. Anything past 2 weeks would be additional. We both agreed to this, and I told her that we could do our best to try to complete what we can in 2 weeks. That's what this was for the 2 weeks of labor, which was also included for the AC units, the 80 hours of work, 2 men, it's the 2 men, which she got 3 men, no extra charge, but she had 2 men, she had 80 hours of work to complete a lot of things around this really big home. That was our start of the estimate.
Okay, so I'll break it down into 2 parts. First, can you describe the house?
The house was a pretty big house. It was 2 different sides of homes. One was the older side, one was the other side where everything was redone. Walls were installed without inspections. So they had walls up and everything without inspections. And we just walked home and went over the kitchen, went over the upstairs bedrooms, went over the bathrooms, which was a lot of stuff that's done the wrong way. So we explained the violations that would be violations. We just, she asked us to please help her.
Okay, and my second question, what was the work when you showed up? Was it complete? Was there a general contractor that
There
had?
was no contractor. Contractor walked away from the job. I don't know why they didn't pull any permits. I don't know why they didn't have any electrical inspections before they closed the walls on. I don't know what was going on, but she said that the contractors walked away and said that they couldn't pull permits. And she asked us, can we please help? I told her I was apprehensive about taking the job. She said, she agreed to the contract and she said that, can we please help her?
Now, I'm a layman, what's the significance for electrical contracting in an older home and the fact that the walls were enclosed?
Well, I guess the walls were tore out at one point and they ran all the electrical. We're supposed to have a city, approved inspection for any walls that's open. You should have an electrical inspector come in and give you an approval sticker where everything is wired correctly, everything should be done before the walls is even closed up. And so that's where we was trying to work with her to where we didn't want her to have to open all the walls back up, because inspectors would make you come and open every wall back up in the whole entire home.
What's involved in opening a wall?
That means tearing it all down, back to studs.
Removing drywall?
Removing drywall back down to studs. Yes.
And when you first arrived in 2023, the summer, was everything covered in drywall?
Everything was covered in drywall.
When I say everything, that's the previous electrical.
That's the previous electrical, brand new electrical was covered up with drywall. I guess they tried to get past the inspection.
Did you ever find out the name of the previous general contractor
No, I did not.
or a previous electrical?
No, she said that it was a gentleman that worked for the previous contract.
May I approach the witness with exhibit B and C? Sir, I'll show you what's marked as exhibit B and C. And ask you, do you know what those are?
These are inspections.
Are those inspections or are those receipts for purchasing a permit?
These are receipts for purchasing a permit.
What's the date? There's two receipts there. What's the date of those receipts?
18/23.
And the payer's name there, Melinda McMurtry, is that your office?
That's my office manager.
She's your office manager. She paid for these, to your knowledge, with the company credit card?
Yes.
And then, later were permits issued to Luminaire Electric?
Yes.
Yeah, approach. Show you what's been marked as exhibit D. Said D. D is a dog. What is that, sir? You know,
This is less.
the number in the upper right, 1512.
Yes.
Why was the second estimate prepared October 4 when the first estimate was dated June 29?
This was additional work that she asked to have done. She wanted to estimate on the generator install, and she wanted to estimate on basement lighting, because she was liking the work that we was doing so far, so she wanted more work done. So we was just giving her an additional estimate for more work done.
All right, let's first generator install. Did that include purchasing the generator, or was she going to buy it?
She was gonna purchase it.
And where would the generator go at this house?
Outside the home.
On a concrete pad, or
Yes, on a concrete pad.
was that done?
No, we didn't do it. This was just an estimate. We didn't get that far because we stopped working there.
Okay, and then the basement, 4-inch cans, what did your estimate entail for the basement 4-inch can?
She had a lot of violations, which we took pictures of. She had a lot of lights to screw to the bottom of the studs, and we were gonna install the proper cans because whoever the contractor was to screw lights to the bottom of the studs had wires hanging everywhere. And he inspected it like that at all, and we knew it was gonna knock.
That the city of Detroit would not approve that?
Would not approve of it, yes.
Was were the basement cans, when you showed up, were they covered in drywall again, or there's?
No, they was not covered in drywall, it was screwed to the bottom of the stud.
And going back to when you showed up in the first instance, did you give the name of a contact at the city of Detroit to the defendant?
No, not when we first showed up. I explained to her that if I told her that since we have to have inspections, that she really needs to talk with the inspectors and let them know that the walls will be closed up. I don't know how she got the idea that we have a personal
Let's not speculate.
Yeah, but for the most part, I let her know that she needs to talk to them because all the walls were closed up. I explained to her that they will make her tear every wall down in the whole home. She needs to explain and really talk, and let's try to, talk with the inspector and see if they can not tear the walls down.
So now this, second estimate was about $14,000 in addition to the first estimate, which was about $18,000. You haven't paid anything at this point, is that right?
Well, this estimate, we didn't do any work. The estimate at first, we did get paid $16,000 and $323, but it was additional work that she asked to have done.
My question was, at the time this second estimate was written,
No,
You
we haven't been,
received-
I haven't been paid
Excuse me,
anything.
excuse me.
Not a dime.
Excuse me, finish your question. Wait for the completion of the question.
I'll ask a different question, sir. At the time that you wrote the second estimate, had you received anything?
No, I haven't.
So at the time you wrote the second estimate, the relationship was good.
Yes.
The defendant liked your work.
Yes,
Was she residing, and her husband residing at the home at the time?
I couldn't tell. She was going back and forth to California a lot.
Sir, I'm gonna show you what's been marked as exhibit E, may I approach?
May I just stop?
And ask if you know what that is.
Questions regarding inspections. And I believe this is. Hey,
So is this an email string, sir, between yourself and Penny?
yes,
She goes by Penny. Is it Penelope? She goes by.
yes,
Is it fair to say this October 11th is when the relationship fell apart?
yes.
Put aside the email for a minute. What was your understanding what she was complaining about? Without reading, just tell me it's your company.
Yeah, from my understanding, what she was complaining about is that she didn't want to pay. She was stating that the guys didn't complete 80 hours. I told her that wasn't true. I said, you always had more than three, you had 3 guys on the job. When I only charged 2, so I was really trying to help her. I gave her 3 guys on the project, and then so it was, even if one went out of town, it was always 2 people to 3 people on a project. So she got 480 hours, not more.
So the original estimate was 80 hours.
Yes.
At 2 electricians.
Yes,
Per
yes,
day.
yes.
And what else was she complaining about? Just your memory.
Just in my memory, it was, I don't know if I was asking for a payment or she just wanted to, she was complaining about, it couldn't have been the inspector at that time, but I know she was complaining that the guys didn't work all the hours. And I told her that that's not true. Check your cameras. I said, you got cameras on the house. I said, the guys was there, they worked all the hours. And I just felt that she was being slick and she was trying not to pay, and she asked us to do a lot of extra work, which I was asking for extra money for the extra work that she did wrong. She gave us a list, a whole list of things to do. And if you go to the, where it say additional work, it's a whole different list of things that she asked us to do. So when we did the additional work, we just wanted to get paid for that work, and we wanted to get paid for our 80 hours. We didn't want anything extra from her. We just wanted to get paid and pass inspection. Simple. That's it. We just wanted to get paid for what we've done.
So you've been in business for 19 years.
Yes.
Have you done other jobs where it's a living thing and things change?
I have no problems with the city of Detroit, no problems with the inspectors around Michigan. I've passed all my inspections. We have a wonderful record. Take a lot of pride in what we do.
So is it fair to characterize on October 11 and 23 is when your business manager, Melinda, sent an email saying, we're just going to go our separate ways. We'll terminate the permit you have.
Yeah, because I told her, the office manager, I said, if she feel like she don't trust us as much as we try to do for her, then I'd rather just resolve it and just not do any more work for her, because things became to the point where I don't want to be stressed when I'm really just trying to help.
May I approach the witness?
Yes.
I'll show you what's been marked as exhibit F. This is Frank, and they ask you what is exhibit F.
This is a letter where, the defendant is actually stating, that they are hiring another company, but we asked Inspector Coleman to remove us from this project, and we needed to send a letter.
Okay, so exhibit F is 4 pages long. The first 2 pages is it her letter to Vincent Cooley at City of Detroit?
Yes.
And the 3rd page, what is that?
Third page, it looks like it's just an approval sticker. I hear it says school relieving luminaire electrical from any duties with Hamilton, 18065 Hamilton Road.
That's what Penny said, correct?
Yes,
What did Vincent Cooley of the City of Detroit say?
he approved it.
And the date?
It was 10/16/23.
And is that the city's job number, 2023-02932?
Yeah, yes, it is.
You've dealt with the city before.
Yes, yes.
And what is the 4th page? Exhibit F?
Fourth page was me giving, and this is in the letter that we had to council our permit.
What's the reason for Luminaire on October 17, 1 day later, to submit a cancellation request for the permit?
Because we have to do that by law to cancel out of the job, as Cooley called me himself, and he was the chief electrical inspector, and he asked me to send a letter in stating that I wanted to be from the project.
And if you didn't have your permit canceled, your company would still be liable for the electrical work, right?
Exactly.
If somebody else finished it, you would still be on the hook.
Yeah, so I told her that it was only pulling a permit for the work that we did, not work was done before, not the work that was done when Streamline Electrical came in. We only wanted to pull a permit for what Luminaire Electrical did. That's what we passed inspection for.
So you told me the house is comprised of old house and new house as an addition.
Yes, yes.
Where was your work, in the old house or the new?
It was in the newer house.
And was it newer addition? Was it brand new? Had unlicensed general built it, or had he just?
It wasn't brand new, it was remodeled.
You ever know what Streamline was the placement contract?
Yes.
You ever know what work they did when it got inspected?
I'm pretty sure it got inspected. I know Streamline personally, and so yeah, I'm pretty sure that when they did it, pretty sure they had to get inspected.
So how do you know that Streamline's work wasn't your work?
We wouldn't know it. That's why we have to cancel ourselves from the permit.
May I approach the witness, Your Honor? I'll show you what the marked as exhibit G. The top of the document says City of Detroit Building Safety Environmental Department, a 3-page document. You know what that is?
I've never seen these documents before, where it looks like this inspection status.
You're aware that the City of Detroit maintains inspection status online, is that correct?
Yes,
Somebody obtained 3-page document there.
yes, yes.
What does this 3-page document report to show? What happened on October 27th?
Yes.
Okay, so on the second page, under Harold Howell's name at 3:18 p.m., it says okay to issue C of a for this permit. Was Harold Powell the inspector on this? No.
Yes, yes.
Who was Marion Swint?
She was, Miriam Swank is the electrical, she's like the clerical chief for electrical down in the city of Detroit at that time.
And this time, this one, which exhibit are you referring to?
I'm sorry, Exhibit G, Your Honor.
All right, thank you. Thank you.
To your knowledge, what does C of A for this permit, what does that tell you? Certificate of approval?
Yeah, I'm pretty sure it's got to do a certificate of approval or something like that.
Now, let me ask you, did you take a picture of the V tag your company got?
I did not at the time. I'm pretty sure my employees got a picture of it.
Well, it's too late. Today is the day of trial. When is the, when was the green sticker issued?
Once the inspector came out to the property and approved it.
Now,
Everything that we done.
how long does it take when your company calls for an inspection for the city to show up?
It could take a week to 2 weeks, depends on how big busy the city is.
We saw on the email that you had the defendant on October 11th. You said the inspector will be there October 17th. Where's that?
Yes.
Is that, who called for the October 17th inspection?
My office manager.
Yeah, approach the witness, Your Honor. Sure, I'll show you the markers. It says H. Two-page document. First one says receipt. Do you know what that is?
Yes, this is a receipt.
That your company generates that?
I generated that just saying. Give me a receipt for the payment that she did pay.
You personally generate it,
Yes,
and that's something that you have on your computer.
yes.
And how is that receipt sent to the customer? Email, US mail?
Email.
And the second page of exhibit H is a check. Is this the check for $16,373?
Yes,
Here's my question. What does this $16,373 represent?
that was the, that was material and labor, so that was the 80 hours for work that was completed. That was the original 80 hours,
Which is 16,000,
16,000 plus the work for the AC units.
and the permit?
Yes.
The permit's not included in this, is it?
Yeah, the permit is included.
Okay. But she only paid $16,373. Did you agree with that number?
I didn't agree with that number because of additional work. If you go to the estimate, the final invoice, it shows the additional work that wasn't on the first page that she was requesting, because as we was moving along, she was adding things to what we originally discussed. So when she added, you go to the final invoice, you'll see additional work on the bottom of the invoice. That's additional work. It doesn't have anything to do with what we first discussed with the 80 hours. And I already expressed to her that we would do our best to complete what we can within 80 hours. And I'm pretty sure that it will go over 2 weeks. She agreed to this, but she also kept adding things on. So we did charge for additional time past the 80 hours. The $16,000, I'm happy that she paid, but we did do additional work. We do deserve just our basic pay. Just be paid. I don't need anything extra. I don't want anything extra. I just want to be paid for the additional time that this is there.
Yeah, approach the witness. I'll show you what's been marked as exhibit I. This is invoice 1832.
Yes,
Now, it's kind of a running commentary because this invoice 1832 starts with the scope of work in June. And then on the second page, it carries over to some more work, doesn't it?
yes.
In the future, would you do 2 separate invoices? So what is the scope of work that was done on the second page?
Local work is done on the second page. It says additional work, finish assembling fixture. Dining room with new parts, run new switching for breakfast nook, switch box, cabinet low voltage.
Excuse me, you're still on the bottom of the first page, right?
Yeah, but that
Carries over.
That carries over.
Excuse me.
Yes. And it says makeup area above, refrigerator. Punch a hole through the kitchen wall for cabinet low voltage wire makeup. Install tape light under cabinet and kitchen. For all additional.
Well, these
Right.
are,
Yeah. Number 5, run new low voltage wire from transformer above microwave to under cab remote microwave. Staple under cabinet lighting wires. Repair under cabinet lighting, cut during backsplash demo. Install cooktop wiring for the cooktop. Install box and outlet or island. Install plate cover for box behind dishwasher. We have 2 additional days and a half a day. Charge anything additional.
what are the 2 additional days?
2 additional days was 2 guys, 1,600, and 1 day, 1,600 for the second.
What
day.
dates?
The first day was 10/3/23, 10/4/23, 10/5/23, 4 hours.
That's the half a day.
Yes,
And these items 1 through 10 listed as additional work on your invoice 1832. Was this work that the defendant requested?
yes, that's what the defendant requested from us, and I have it down, requested by, owner. As the guys was moving along, they wrote up anything additional that she asked us to do. She asked us to, but they didn't create it.
No further questions.
Thank you. Your inquiry at this time, Mr. Coleman.
How did you first meet Ms. Jackson?
I believe it was referred, to her either from Angie's List or. Pretty sure it was Angie's List.
And when you discussed with her about the project, there was conversation with her to create this contract.
Yes.
And there was discussion about the importance of form permits and project. How come on your initial estimate exhibit A, it references a $1,400 line item for electric permit cost rest last?
We didn't know what we was gonna have to put on the permit. So that's why we learned the cost of permit, because there was so much stuff that was done. When you're doing a permit, the city of Detroit can ask for $15 per circuit. She had a 200 amp panel installed. So all the circuits that she ran through their home, we didn't know what we was gonna have to cover. So we have to be prepared for that. We didn't want to go in and not be able to calculate everything that's in Detroit. See, Detroit is pretty high on the inspections. And there was a lot of stuff that was done. Once we didn't take responsibility and we pulled off the job, I was able to lower the cost.
When did you commence your work on the project?
Right, since
When did you start working on the project?
should be a date in 2036. Some exact date or not. Previously, pretty sure it's the date.
And it's your testimony today that you had 2 guys working 4 weeks, for 2 weeks straight.
Yes, 2 guys, 2 to 3 guys. I gave her extra guys. I was just trying to help Ms. Jackson. Just help her. I didn't care about, I just wanted to be paid for the hourly guys, make a little money and give her extra guys just to get my life done. It's a lot to do. I didn't find, I figured, here, this guy is, let me send an extra guy just to help out. So she had 2 to 3 guys consistently every day.
What documents do you have with this for payroll that was actually paid for this?
I didn't bring the document today, but we do have a payroll company, so we do have everything on payroll that we pay the guys. We do have, payroll system, which is paychecks.
And as you sit here today, if you look at your initial estimate that was marked as exhibit A, you acknowledge that all the work. It's not.
Excuse me.
If you look at the exhibit A that was handed to you,
Okay.
you acknowledge that Luminaire did not complete all of the work. that's in there.
Yes, we did complete all of our work that was completed. We completed our work that was completed. There was a lot more to do. And that's why she's adding on more projects, but there's a lot to do. We got a lot done. It must be a page there of everything that we did.
So it's your testimony that you didn't do any of the work that was in the subsequent inputs that was issued.
Sorry.
You testified that there was also an invoice he had handed you that you didn't perform any of the work. It's your testimony that that's not the initial estimate. That was the subsequent invoice that you had issued to the board.
I think you're asking me,
Are you saying that Luminaire did not perform any of the work identified on the exhibit?
you performed work that was asked of us.
Not my question. The question is, if you look at exhibit E that's in front of you, you will confirm that none of that work was performed by Luminaire.
Exhibit E, right?
D.
E. This was the generator. Did not install a generator. No, did not.
How many times were you at the property while Luminaire was employed on the job?
Was myself on the property?
Yourself.
Maybe 3 times, 4 times, just to check for it. First time with the owner, and the other time just to check on the guy's progress.
Documents like the exhibit A and exhibit D that were introduced by your attorney, how are those transmitted to the defendant?
So exhibit A is the estimate for the first work. Exhibit D is work that we did not do in the basement or the transfer switch or the generator.
The question is, how does Luminaire send that or hand that? You hand it to the customer, you email it to them.
I emailed it to the customer.
Who was Harold Howell?
Harold Howell is an electrical inspector.
And he works for the city of Detroit.
Works for the city of Detroit.
Aside from his official capacity as inspector of the city of Detroit, do you have him inspect properties? Correct?
No, I did not. Only for the city of Detroit.
So then every inspection that you allege was conducted at this property, there's a record of the city of Detroit. Is that correct?
Yes.
Earlier today, you testified regarding the letter that was addressed to Mr. Cooley regarding the meeting of Luminaire when Ms. Jackson brought Streamline on the project.
Yes.
Correct. Isn't it true that you didn't complete the scope of work and that's why Streamline was brought in to finish the job?
I walked away from the project because I got to trust Ms. Jackson. So anything that Streamline completed, it was not work that we had to complete. It was projects, because it's tons of projects that need to be complete. In the attic, in the basement, whether she had her generator installed, where wasn't projects that we had, anything that we touched, we was approved for by the city of Detroit. We got, and I made sure that we went through and broke down everything that we needed. And that's what the inspector went through and checked everything we did and passed us with a green sticker for what we touched. Anything that wasn't touched was what she hired them to do because we walked away after receiving and doing additional work.
Let's talk about green stickers. Do you only do renovations or do new construction?
I do new construction also.
How many inspections are there generally for an electrical scope of work, regardless of whether it's a renovation or construction?
How many inspections?
Yeah.
It could be 3 inspections. Are you doing new, are you speaking of new construction or remodel construction?
Customarily, wouldn't you get a rough electrical and a finished electrical?
Yes, you would.
It's your position here that the city of Detroit gave you a special approval just for a certain scope of work that you've done.
So what are you asking?
You just said that you got a green sticker approval for the work that you had done before street limits work.
Exactly.
And I'm asking, so the city of Detroit gave you a special approval outside of what would be a rough or a finished electrical?
They don't give special approvals. It's special approvals.
Well, I've never heard of a contractor getting an approval sticker for the scope of work that you want. So I'm asking, what is the understanding of this approval?
You can get in new construction, you can get a rough inspection, which her home would have been considered new construction. And she would have left all the walls open, like she should have. That would have been considered a rough inspection. That's your rough. After your walls are installed, you can get a ceiling inspection. You can get a final inspection. After that, you can get a final inspection. Her walls was already finished. So we don't go and get a rough inspection because now her walls was finished because they should have been finished. The only thing we had to do was call for inspection for the work that we done. So where she had the walls open was right in the bathroom on the 2nd floor, where she had a GFI was located in the wrong place because you have to have a certain type of GFI. They have to be above the tub in an accessible point. So that was the only area where the walls was open. So we can get a rough inspection for that one wall. That was it. If we was to get a rough inspection, the rest of the house was complete. So when you got a jacuzzi tub, you have to have where the outlet go in the tubs, you have to have a certain type of blank GFI, where the GFI will actually trip. You can press the reset button up high, and not have to go in the tub. It was in the wrong location, and we remounted that, put it in the right place for her. That's the only place where she had the walls open. Other than that, the whole house couldn't get a rough inspection because she finished it off. And knowing she needed to have a rough inspection.
If you turn to Exhibit G, it was handed to you by your attorney. It's the status history.
Right.
It identifies the electrical permit at the top. That was your permit. Correct?
Yes.
How many inspections does it identify that took place associated with this work?
It says 1017. It says 1027.
Right, so it says the status time was on 10/17, it was updated on 27.
Okay, so
There was
where's
one
the
inspection.
inspection?
Okay. During your performance of the work, did you send and correspond with Ms. Jackson alleging that there were other inspections that take place?
Did I correspond with her about other inspections on the property?
Yep.
No, I did not.
May I approach your honor? I'm going to hand you what is marked as Defendant's Exhibit 2. You recognize this text thread? Yeah, I apologize, your honor.
have a magnifying glass.
Just one.
I will get there. Hold on. I'm just gonna give you one of everything. Ready? Yes, sir. All right. Do you recognize this text? I'm not necessarily saying the document or the images embedded into the text.
I don't recognize the text because I can't read it.
Well, you agree you're Damian Jackson, correct?
Yes.
All right. May I approach exhibit 3, Your Honor? And your document that has been admitted as defendant's exhibit 3. I'll represent to you that is a printout of the picture that's embedded into that text. Do you recognize that?
Yeah, what is your question?
Do you recognize this document?
No, I don't recognize it. I can't look at it now. I understand what's going on. Memory, probably don't.
Do you see that it identifies an inspection report dated October 6, 2023?
Yes.
However, when we looked at the city of Detroit records, there was no inspection on October 6th.
Right.
And you are Damian Jackson, a job location at 18065.
Yes.
But as you sit here today under oath, you don't recall sending this in a text message.
I don't remember saying it. If it was sent, I don't remember saying it.
Do you know who prepared the document?
No.
Do you know who Luminaire told Ms. Jackson wasn't inspected at this inspection? Harold Howell.
Okay.
I'm asking if you're aware
Am I aware of what?
that it was represented that Harold Howell, the city of Detroit inspector, had conducted this inspection. City of Detroit, this is not an official inspection. Generated by the city of Detroit.
I'm not understanding what you're saying.
Okay. Are you aware after that this inspection took place, Ms. Jackson became concerned about whether there were legitimate inspections taking place on the property?
I'm not concerned. I wasn't concerned about that because she got an actual inspection from the city of Detroit.
I said, were you aware that Ms. Jackson became concerned regarding whether there were legitimate inspections taking place?
No, I don't. She didn't tell us that she was concerned about anything. Ms. Jackson just was coming up with excuses not to pay or it won't work. So no, I have no idea what this is.
Well, you just indicated that she was making excuses not to pay, but earlier in your testimony was you had to try to invoice work.
Did not invoice her until we got paid, but she was starting, yes, at this time. We don't remember, I have no idea. I don't remember the document. It's a long time ago. All I know is that we tried to help Ms. Jackson. We did tell her we did not have any inspections done by the city of Detroit that wasn't by law. The city of Detroit came and they gave us an approval sticker for everything that we touched. That's what I do.
Let me rephrase the question. Exhibit 3 that you're holding right there. Is that an official city of Detroit inspection report that you've ever seen generated?
No, I don't.
Are you aware that Ms. Jackson subsequently engaged Streamline Electric to finish the electrical project?
Yes,
Are you aware that they pulled the permits?
yes,
Are you aware that they called an inspection before they commenced the project?
yes.
Is it your position that the violations that were noted that day related to the work of the previous contractor?
Any violations that Streamline had wasn't from our work. We passed everything that we touched. Everything that we touched, we got the sticker report. And we took our time and did everything up to go. Anything streamlined there is additional.
When you started your work on the project, did you call an inspection?
Yes. We called for inspection when we first started the project. Well, we did.
So how would the city of Detroit know what exactly you did in the project versus what previous contractor?
Because we wrote it down, to ask the city to inspect everything that we did.
And that this approval sticker you're talking about, you don't have a copy. Correct?
No, we don't have no ones right now. I'm pretty sure we have pictures of it. I didn't know I was supposed to bring it before.
You don't say it's in trial.
Yes, I know it's today's turn. And then you also see in ways where it says it's approved, all our work is approved.
You ultimately had issued a invoice to Ms. Jackson. That was for over $22,000, is that correct?
Don't remember that. What was that? What did you give me that?
Oh, you were holding it in your hand. I handed you as. I will hand it to you as Appendix Exhibit 6. That was also part of this one.
H.
Pardon me, I approach.
You have exhibit H already, so.
There's a page. It's just a field.
All right. Do you recognize the document I just handed you?
Yes.
Do you know what date this was actually issued to Ms. Jackson?
It says 6/23/23.
No, I understand that, but if you look at the initial invoice, that's when that was, the date carries over through all of these. So there's no way for me to look at this and tell what date you actually issued the invoice to. We had just discussed in October, you hadn't yet billed her, so I looked at the candidate in October, I'm asking, when did you send her the final invoice?
On this date says 8/10/23. This was a final invoice for everything. I do understand that very well. As far as the dates, 8/10/23, and it says 6/23. Are you talking about dates between words? It says 6/23/23.
I'm saying if I look at your initial invoice that was marked as Exhibit A, it says 8/10/23 on it. So does your final.
So that might be when invoice was started. Because right here on the back page, you have where the additional dates for the additional work was done. And 10/6/23. So maybe the initial invoice got started 8/10/23.
So you admit with me, you probably couldn't have generated something after October 6th.
Are you asking again?
You said you just added additional work on October 6th, so I'm saying.
October 3rd, October 4th, October 5th.
So it'd be fair to assume this invoice was like generated at least October 6th.
That's when work was added on to the invoice. These dates, actually, we had to do the dates afterwards. It's not when the invoice was generated. That's not when it was started.
I'm asking when it would have been presented to Ms. Jackson.
It's not saying it right there on the invoice, the date is actually sent to her.
After the invoice was sent to Ms. Jackson, did Ms. Jackson dispute the amount of it?
I don't remember if Ms. Jackson disputed it. I do know she didn't want to pay the bill. She kept saying, matter of fact, go to your documents. She basically just told us that she would give us a check after she had some more inspections. She wanted an inspector to come in after our inspector left and approve us. And then she had another inspector come in, and she wanted, first she told us that the inspection was completed for the basement, but we have more to do, where we had to inspect the ceiling lights on the second floor and things above the drywall. And I replied back to her and said that we didn't do anything inside your walls, have anything to do with us. I said, we didn't touch anything inside your walls. So she was having her own inspections. And that's where we was having a problem. We didn't know that she was just gonna pay just the $16,000 and then tell us that she wasn't paying anymore. We didn't know that at first until after our inspections was finally paid. And then she just basically wrote us a check and she said that I'll see you in court for the rest of it. We didn't know that she wasn't paying anything else as far as, she just had her own inspections. And I'm looking for that paper. You can see the her paperwork also. And we left her emails, we did an email for her where she was telling us that, hooray, we got an approval, but we still have a hurdle to go.
Question is, you're aware that once she got this invoice of $22,000, she disputed the balance.
No, she didn't dispute the balance until, I don't remember.
Do you have a Gmail account?
I do have a Gmail.
What's your email? What's your email address?
Lemire, Detroit@gmail.com.
So if there was emails exchanged to you in December of 2023 disputing the invoice, you dispute that you got those emails from Ms. Jackson? I'm not saying you're holding them in your hand. I'm just asking if Ms. Jackson had sent an email to you.
It could have. I'm not trying to argue everything. I'm just trying to basically get paid for what we've done.
Okay. So
I'm not trying to argue what was argued because that would be a waste of my time.
So let me ask you a question, Council, if it's okay with you, then witnesses will be allowed to answer if you want to do something different. We'll have to answer that question. That question is, did you conclude that that the defendant was disputing various charges when she refused to pay?
When she refused to pay, yes, at that point, yes, sir.
Council, I'm striking it.
No, I'm not good with it. All right, and then subsequent to that, she issued a check to you for over $16,000.
Yes.
After that, is your position that you would send her a follow-up invoice claiming there's still a balance still?
Yes.
Okay, what do you have with you today that shows you actually transmitted a subsequent invoice to her claiming that that $16,000 check was?
Balance right here. She said to her.
I'm asking what email, what cover letter, what do you have with you today to show that you did print that your office was actually transmitted to?
Because every time I send it for an invoice, every time I do an invoice, I send it to the customer.
But you don't have an email with you today showing that that was attached.
I don't have an email showing that it's attached.
Had you previously filed a lawsuit against Ms. Jackson and her husband in the Wayne County Circuit Court?
My attorney did. I put a lien on her property. I put a lien on her property for the whole amount. Before she decided to pay me the $16,000, she paid me the $16,000 after she received the lien. I had a lien on her, and then she paid the $16,000. No worries about. I put the lien in the attorney. Trying to think how this went. Like I said, it was a couple years ago. So the attorney, I remember putting a lien on her property. And the attorney, I told him to go ahead and do what he needs to do.
I don't want to know about the conversation you had.
Yeah, but I'm trying to figure out, like I said, it was a while ago.
Let's go back to, let me stop you. Stop. Your question, Council.
Right. But after that lien was reported and a lawsuit was filed, you received the payment for $16,000.
Yes.
And then ultimately that case was dismissed.
Ultimately, that case was
dismissed.
Well, no, the case wasn't dismissed because she still had a balance of $5,900. She still had a balance.
I will represent to the court that the case ultimately was dismissed. I believe we're non-service, but it was dismissed.
Yeah. And so to try and clear that up, There was no case pending in circuit court at this time.
No, no.
That's correct. I mean,
Yeah.
the lien eventually went stale because the lawsuit was dismissed.
Yeah, I don't understand why legal just so.
All right. Nothing further.
Are you hungry or at this time, sir?
No, Your Honor.
Or you may step down if it's not.
All right.
Just, one moment, sir. I know that, no, he should be shut for just a moment. I have a question. I can ask it from there, and you can stand right
I'll
there.
have a seat.
I know that there were two items based on your testimony that you threw up, and they're included in exhibits as proposed contractual agreements. That was the initial one in June, and then a subsequent document that you prepared for services, including the installation of a generator. Was to be a part of that scope of work, correct?
It was a different scope of work.
Yeah, and that was the second item that you made reference to as a second contract that work was never done, correct?
Exactly.
So in the initial contract, I guess where my question lies is in relationship to work done outside of the four corners of that initial contract. You indicated there were things that were requested along the way. Were those things documented in the first contract, or were they documented somewhere else?
Well, I have my employees write down any additional work that she actually done, and that's how we know what to bill and the time it's taken to get it done. So that's what we did.
You didn't generate another contractual document regarding the additional work that was requested, correct?
No, I did not, because we had explained.
Yes,
to her-
that's what, thank you.
Yes.
In that first contract, you had some language that limited the number of hours of work that would be done, correct?
Yes, sir.
So today, what you're saying is that the amount of work that was done in terms of time and scope was beyond that first contract, that additional work is what you're asking.
Yes.
All right. Now, you're not asking for recovery on the second contractual document that was presented, correct?
No, not on any work for the generator. We didn't do it.
Or any inquiry as a result of the question you make?
Yes, Your Honor. Mr. Jackson, first estimate was $18,000. The total bill came to $22,000. So what's the extra work that you billed?
Well, we already covered that. That's already been offered by way of testimony, unless there was something specific.
Relative to the judge's question, is this outside the scope of the first contract?
It was additional work that was done. That was why it's additional from the 18,000. The first 18,000 was when we gave her an estimate. We had included to the price of the AC units. Was going to be separate, and she told us that she wanted us to add the AC units inside of our 40 hours. So that's how we was going to be able to stay within our 40 hours. Our 80 hours was, the AC was going to be additional. But she told us to change it from the 18,000. She told us to remove the AC units and put it within our 80 hours. We said we will do the best we can. And we also stated that this could take more than 80 hours. And anything additional will be additional. If any additional time, it will be additional pricing.
Thank you, Counsel. Thank you, sir. That's testimony that already been offered. Mine was just to drill down on whether or not there was an intervening contractual document. That's all I asked about. That testimony has already been set forth as to what the charge from 18 to 20 some thousand was about. My question was whether or not there was a subsequent written document. That was a clarification. That's what I was asking about. So I don't think you'd have to rehash the testimony. That there are additional questions centered around what the court scope was. My scope was simply, okay, I've heard your testimony, kind of a bit of the valuable benefit of labor reform beyond the contract My question was there another written document? The testimony said it was not another written document. That's all I was inquiring. Okay, any other questions in that regard?
I have one. Why did you bill for work on October 4th, 5th, and 6th? When the second estimate was dated October 4th. Second estimate is dated October 4th. And then you go and bill for work on October 4th, 5th, and 6th. What's the work on October 4th, 5th, and 6th for?
Those was days where we did additional work and the time.
That's already, let me stop you there. That's already in the testimony up there. You already testified to those guys. I have that document as to what the testimony is. So, and I didn't want my inquiry doesn't take away what the testimony was. My inquiry was just whether or not there was an additional document that drew those things into some written document. It doesn't have to be a written document for the parties that have a contractual relationship. I just want to know that there was something that was missing here. I wanted to see that. That's why I made that. All right, Council, you may.
I call Ms. Jackson.
Plaintiff rests, Your Honor.
No further questions of you. Excuse me. One
No, no, you're on.
All right, thank you. All right, plaintiff, having rested, you may at this time proceed. You may be seated, sir. Okay. In just one moment, ma'am. State your name for the record. A little bit louder.
Penelope Justina Abiola, family Lucy Jackson.
All right, thank you. Ms. Jackson, raise your right hand this morning. You do solemnly swear affirm that the testimony you're about to give is true. So, you may be seated at this time. Thank you. Thank you.
Judge, I'm sorry, Judge. Her name is Penelope. I didn't get the last name.
Justina Abiola, family Lucy Jackson.
Do you need some spellings, Madam Counsel, Madam Reporter?
Yeah, or I can just get it, come down there and get it later. But the last name is Jackson.
The last name is Lucy Jackson.
All right, that's.
Oh, okay. I have that then. All right, thank you. I have that, Judge.
Got it. All right, thank you.
Uh-huh.
You talked about it, so you might have to. All right. Where do you currently reside?
18065 Hamilton Road, Detroit.
And do you know when this home was built?
100 years ago.
I'm sorry, I didn't hear you.
100 years ago.
Okay. When did you acquire the property?
Back in October, November 2021.
After you acquired the property, you want to take some renovations.
Yes, about a year or so.
And did you hire a general contractor for that?
Yes, I did.
And did your general contractor pull permits for their work?
Unfortunately, they did not.
When the issue of the unpermitted work came to your attention, did you ultimately part ways with that contractor?
Yes,
Was it important for you for the work to be permitted and inspected?
correct.
Ultimately, how did you come to learn about preliminary?
I had consulted some folks about what we needed to do to get my house inspected because we had plumbing work and electrical work that had not been permitted, and I was concerned. I didn't want to move into the house until I knew it was safe. So I consulted somebody who said, well, you have to find electricians and plumbers who would be willing to get full permits on the work that's done, as well as make sure that any work that gets done on your home is permitted. So I started searching for electricians and plumbers that would work in the city of Detroit. Okay, I found a plumber, and then I had actually I contacted Luminaria initially because I wanted my heating and cooling folks had installed the AC and they needed some electrical work done. And so it was work that was not done previously by the previous contractors. So I found Luminaria. I think I Googled contractors that work in the city of Detroit, and they sent somebody there to give me an estimate. I wouldn't say I wasn't impressed. I thought the gentleman was kind of young, so I opted not to hire them at that point in time to do that AC work. But then I was at Lowe's, ironically enough, like a few weeks later, and I saw a couple of Luminaria trucks, so I realized maybe the company is a little bit bigger than I thought. So I called them back and asked them if they could send me a more senior person to come give me a price. And the person on the phone said she would send Danny Jackson. And that's how I didn't, unfortunately, I didn't do any reviews, I didn't do any of that stuff. I just, you know, my instinct, I said, let me call him and get him over here. And that's how.
Okay. So you met with Mr. Jackson, did you discuss the importance of making sure a permit was pulled and inspections were done?
Yes, I explained to him that the previous contractors had not, and he had, I said, and I told him that I need the house inspected. And I was fully aware that the inspectors could end up tearing down all the drywall work or some of the drywall work. I knew that from people that I had reached out to ask, how can I fix this? Because I can't live in this house without inspections. So he had said they would have to pull multiple permits. And he gave me a price right then and there. He said this is going to be, and I gave him a piece of paper with the scope of work that I believed that was the work that needs to be done. It was a page and a half or 2 pages of scope of work. He looked at it, we walked through the house, we talked through everything. He said this would be 2 hours, two weeks and 2 guys. I balked at the cost, the 20,000, because I was thinking to myself, my God, how much is this going to cost me? He said, don't worry. If we go over this, we'll have a discussion. And if after you have your inspections, there's additional work to be done, we will have a discussion. So I was fully under the impression I was going to have to pay that, whatever it was, for the 80 hours times 2, the 16. I was fully aware that I was going to pay that. I did not expect to have these add-ons because I was not even told that there was extra work that needed to be done. I did not add, I added one item, okay, that I added extra in addition to the scope work, which was to put a plug in the island. That was the only additional work that I had not discussed with the gentleman that was doing the job. I only saw Damien once, which was when I got the estimate. I never saw him at all. When he gave me the estimate initially, I was away in California. I came back specifically to manage the electrical project because I also had the plumbers in the house as well. And I wasn't going to make the same mistake as before, and I wanted to manage this. In fact, I micromanaged the project on a regular routine basis. There were times when there were not 2 gentlemen there. The lead person, whose name was Jacob, was present for the first day and then disappeared, so I complained. They sent somebody else, another person. At one time, one day there was 3 people because I had sent to call Jacob because I was very upset about the mess that they were leaving. And he sent somebody over to clean the project because there was just mess everywhere, and I just asked them to be clean as they go. During the project, they had to leave. They had a project, Jacob reached out to me and said that there would be nobody at our project for a couple of days because they had a project they were doing in Porktown. At that time, I told him, well then, because it was hourly, right? Because it wasn't a set price on the work, it was hourly. I specifically said to him, you will owe me that on the back end. Meaning if I'm not going to have somebody there, or 2 guys there for these days that you're going to Porktown, you're going to owe me that work. And that's what I explained to him. As we started to get near they had already been there, I was questioning why, and the gentleman that was the main person at that point in time, his name was Tyree, I don't know his last name, I kept questioning him why we weren't having inspections. And the reason why I felt I was worried about that was because I already had 2 or 3 inspections with plumbers, and they were there during the same period. So I couldn't figure out why I wasn't getting inspections. So eventually, Mr. Jackson called me, reached out to me, and he kept saying to me, hasn't Mr. Harold called you? Hasn't Mr. Howell called you? And I said, who is that? And he said, the person that's going to do your inspection. And I was very confused by it because I had no interaction with plumbing inspectors. No plumber inspector reached out to me saying, let me set up an inspection for you. It was just new. I didn't understand that. Then he sent me a text message saying that the inspector would be there on Monday and that he would be there as well. And Monday was 6/5/4/2, October 2nd, 2023. I got a text message from Damien said he would be there with Harold, the inspector. October 2nd came and went, October 3rd, October 4th, October 5th came and went. Harold Howell showed up on October 6th. Unbeknownst to me, I was actually just leaving the house and he pulled up, but I didn't know who he was. He told me he was from the city of Detroit to do this inspection. I said, well, nobody's here because nobody was on the property for a couple of days. So I said, oh, okay. I noted that he didn't have a notepad, he didn't have a pen, he didn't have anything, he didn't look official at all. But I asked him to show me his badge because I was a little uncomfortable. So he showed me his badge. So I said, okay, well, let's go through the property. So I took him to, I didn't know what I was to show him, right? I wasn't prepared because I didn't know. So I took him to the basement. I asked him about the lights in the basement, because Jacob had mentioned something to me that he thought that the previous people did it correctly. Jacob was one of the luminaries folks. I asked Harold about it, Mr. Howard or Mr. Howell, and he said there was nothing wrong with the lights. He was fine. So I said, okay, that's all I knew to show him in the basement. We didn't go anywhere else in the basement. Then I said, well, let's go up to the attic. So I took him up to the attic because there's a panel up there. I asked him about some wiring, whether or not we had to do anything electrical, because this is stuff that I kind of knew a little bit about. I said, do you have to do anything with all these electrical wires in the attic? He said, no, we're not finishing the attic. I said, okay. I said, well, let's go back down to the basement and maybe, I don't know, do you need to see the panel, like the main panel? And he said, look, I really don't have time for all of this. I'm going to call David. And I said, oh, okay. So that was it. He left. And then the Sunday, 2 days after he left, I got the text message, a group text, which Damian Jackson was on, Tyree, the one electrical person he sent, as well as Jacob, saying that they had an inspection report from the inspector. And that was Damian that said that, and he gave that document. Now, I want to back up a little bit though.
Let's go to question now.
I want to go back to, yeah, because I left the report piece.
We'll get there. All right. You're on man approach. Okay. All right. So I want to just discuss some of the exhibits I believe testified about what we walk through. I'm handing you defendant's exhibit 1. You recognize the document?
Yes.
All right. Was this the invoice that you, or the estimate you received after your first meeting with? Correct. And this was the invoice that talked about it would be 2 men for 80 hours, and you were hoping that, correct?
Yes, I was surprised to see the electrical lighting, install the AC condensers, because that's the original estimate they gave me when I hired them, when I first met with them. So I was surprised that it wasn't included in the 16 because we talked about it.
Right.
So when I said to him, we talked about that, since you're now doing the whole house, it would be under the 80 hours, and he adjusted that email and only charged me for the materials for the 16 electrical lighting. Revise the estimate.
Even though the left side of that document identifies a June date for the entry of the estimate, you agree with that work didn't actually start performing.
Correct. I was away.
That Luminaire didn't start performing its work in June of that. In fact, it was months before they actually had started.
That was, yes, because I wanted to be present while they were doing the work, and I was on the project in California for the project.
Right. And then you had testified at some point during the work you became concerned because you had dealt with or advised that those plumbing inspections. Yes, electrical inspections, correct?
Correct.
All right. And would that be around some point in September 2023 when that issue arose?
Yes, I was rising frequently, but I was getting louder about it because I was concerned.
Okay. And then it was in early October that you had first became aware that Mr. Howell was at the project. Is that correct?
Yes.
All right.
I heard his name because I had a conversation with Mr. Jackson about the inspections and my concern, about the work not being completed in the house. How are we going to have an inspection? What type of inspection this is? And that's when he said to me, don't worry, if you take care of Mr. Howell, he'll take care of you.
All right, and what did you understand that to mean?
I gave him money,
When did you do that?
and I refused to do that.
After Mr. Howell was at your house, did you receive a copy of the alleged inspection?
Yes, on a Sunday.
Your Honor, may I approach? And hand you what's marked as, I will just give you exhibits 2 and 3 at the same time. Did you recognize the text message that's identified as exhibit 2?
Yes,
And is that the text message you had received on the Sunday, 2 days after you had met Mr. Howell?
correct, yes.
All right, and you were led to believe that was the inspection report of your property, right?
Yes, correct.
In fact, it identifies, it says no luminaire, but that luminaire mentions Damien Jackson in your house, correct? If you look at exhibit 3, which is a better printout of that inspection report, do you have concerns regarding some of the areas that were identified in this inspection?
Yes, I do.
Why so?
Well, first of all, I tried to look up all these codes, and that was tough. But then I just, knowing the house as much as I know it now, because I was in it at the time, I questioned all of these things because, for example, okay, under this 214 part of the rules are 80.22.2, properly installed ground electrode system, properly installed grounding bridge, properly installed grounding electrical conductor and water meter. Mr. Howell never went into the laundry room. Okay, so that was my concern. Where did he get this information from? The GFCI shall be installed in the jetted tub in the master bathroom. That work was done by luminary. All recessed LED lights in the basement shall be properly installed. Fixtures cannot be secured with water. I asked him about that because Jacob or Tyree had brought that to my attention, and he said they were fine because the ceiling was open. And existing wiring method installed in the attic space shall be properly protected. Again, Tyree and Jacob had mentioned that to me, but when I asked him when we were in the attic, he said it was fine as long as you were not in closing the attic. It was fine to have it similar to that. And so I questioned this, like it made no sense to me. It wasn't, I'd already seen plumbing inspections, so I knew what they looked like when they come from the city because they have the city logo, it's green and white. I didn't understand this, and I immediately questioned the validity of this. I was told Mr. Jackson would call me to discuss, and I did not hear from him. And then shortly after that, because of the comment made about giving the inspector some money, then I saw this, then I immediately reached out to my attorney, and I said,
I don't want you to go conversation with the attorney.
okay.
And after that inspection was presented to you, you became concerned. Ultimately, there was a separation between you and your parent.
Yeah, immediately. It was a couple of days after this, I got worried and I instructed Streamline, I engaged Streamline. I made them aware of the first contractor, my second contractor, and they then agreed that they would take on the work. They got proper inspections. They also, I did a 3-way conference call with Mr. Vince Cooley and the owner of Streamline on Friday, I believe it was Friday the 6th, if I'm not mistaken. We did it on a Friday. We did it on a, and Mr. Cooley at that point in time said to me.
Can't let you tell me what somebody else is saying.
Oh, what he was on.
All right, well,
Oh, okay.
all right. The inspection with Mr. Howell took place on October 16th. I believe the following Friday, you had a conversation with Mr. Cooley. You know, at the court, first of all, who is Mr. Cooley?
Mr. Cooley is he's Mr. Harold Howell's supervisor. He's
At the time, he was the head inspector for the electrical department.
Yeah, electrical department of the city of Detroit.
And you had a call with Mr. Cooley and Streamline.
And Streamline.
And you had discussed that you wanted Streamline to come on the job and to finish the work. During that call, was there any conversation, or did you learn that the city of Detroit did not have any record of inspection?
Correct.
And what did Streamline proceed to do to make sure that they documented the condition?
What did Streamline do?
Yeah.
They came and they So they ordered an inspection.
Your Honor, may I approach? Hand you what is defendant's exhibit 4. You've seen this document before?
Correct, yes.
All right.
Streamline sent it to me after they received it.
Okay. And then it's your understanding this was the inspection that was done by the city of Detroit for Streamline to be able to document the condition of the property before the pass. Correct?
The city, Mr. Cooley told me that that was required.
Okay. And if you look at the middle of the page, it identifies the inspection result was a fail, and then it lists a list of violations with the condition. Correct?
Right.
Okay. After that happened, or around the same time this happening, you also have signed a document leaving Luminaire from its electrical firm, right? Right. And you did that voluntarily so that Streamline could come on the job and perform the work with proper inspections.
That was the conference call. They needed to walk me through the process of getting rid of Luminaire and hiring Streamline.
Okay. Ultimately, you paid Streamline a substantial sum of money to complete and correct the work that was done. All right. Your Honor, may I approach? Okay. I'm going to hand you Exhibit 5. Do you recognize this document?
Yes, I do.
This was an invoice that you had received from Streamline,
Yes, correct.
and there's 2 different invoices that are attached.
Correct.
And they total just over $20,000. And this is the amount you had paid Streamline to come in and correct the violations that were there at the time it became the job. And you paid Streamline for this work. After Streamline came on the job, did you ultimately receive a subsequent invoice, or the first invoice, we'll say, from Luminaire, where he was actually finally asking you? And prior to that, you had never once received an invoice or asking for it, correct? I'm going to hand you what we will mark as Defendant's Exhibit 6. This is the invoice you would receive from Luminaire after they were removed from the job. Is that correct?
Correct.
Did you dispute this invoice?
Yes.
Do you believe that Luminaire ever gave you 2 guys for a full 80 hours on the job?
No, I don't.
Why do you not believe that?
Because I was present 90% of the time. And I know the days that they were there. I know the start times, the end times, because I also complained about one of the gentlemen being in the car for an hour and a half every time for lunch and still only being on site for 8 hours. And I complained about that as well, because I felt that I should be paid for an hour and a half lunch break. I micromanaged this because of the fact that it was an hourly job, and I felt it's going to be hourly, I have to get my hourly work. I'm not, if it was a set price, it would be different. They could have, they could have done it, could have taken them a year because it was a set price, but because it was hourly, I felt I needed to manage it, and I needed to be present because because of our previous issues with contractors.
And I believe earlier you said that the only additional work you believe that actually took place was 1 GFI property.
Correct. And let me just also say one other.
No question.
As we review this invoice, there's a bunch of additional hours. Do you dispute those hours? Do you dispute that they even are entitled to the 80 hours that you're asking?
Well, I should actually dispute all of that too, but in actual fact, I'm just disputing the extra because they laid it out in the email or in this thing as to what the work that they did, and it doesn't add up because I was present.
Earlier, you heard me ask Mr. Jackson if you disputed that. Is that correct?
Correct.
And you did.
Yes.
Is that correct? I'm going to hand you what is marked as Exhibit 7. Starts at the bottom of that first page. It's not 4 but you recognize this email?
Yes.
What is the date of this email? Or how about this? What is the date of the email that you would have sent to Mr. Jackson? It appears to be December 4th, 2023. You started at the bottom of the first page. Your email is
Referring to exhibit 7?
Exhibit 7. At the bottom of the page, it looks like your email is sellerip@me.com.
Yep.
You're sending this about the final payment on December 4th, 2023 to Damien Jackson, correct?
Correct.
And you sent this to him disputing that invoice that you had received for 20,000.
I sent this email, but I questioned the invoice previously by text message.
And then in this email, you had provided a more detailed explanation of why you were disputing. Regarding the electrical permit and the line item for $1,000, you were disputing the request for the payment for that $1,000.
Correct.
As you stated today, you learned that the electrical permit only costs $487. Regarding the additional work that they were attempting to invoice for October 3rd, 4th, 5th, 6th, why do you dispute the additional work?
Because the work was in the original scope of work. It wasn't extra work. It wasn't work that I added. It was already in the original scope of work. The only discussion I had with them regarding like a change was we were going to do lighting in the stairs. Okay, and I said to them, you know what? Let's cancel that. And he had suggested, well, you don't have an under lighting cabinet, so why don't you just what we're going to put the stairs, you just put under the cabinet. I said, okay. It was an even swap.
All right, and then in your email, you're asking him to negotiate the bill in exchange for a final hold waiver.
Correct.
And that is dated December 4th, 2020. Right. And ultimately, you did issue a check to Mr. Jackson, correct?
Yes. And I did not issue it for the permits because I asked for a copy of the permits because he told me the permit costs were going to be, the cost of the permits were going to be a pass through. So I wanted to know what the total cost of the permits were going to be.
Did you ever receive that information?
No.
What I just handed you is marked as this defendant's exhibit B. That is a check made payable to Coleman here in the amount of $16,378.02.
Correct.
All right. This shows that it was cash. This is printed out. Correct.
Correct.
All right. After this was cashed on and posted on November or January 4th of 2024, did you hear from Damien? Did you receive a copy of the invoice that he presented today that alleged you still owe $5,900?
No.
Did you consider this matter resolved?
Yes.
Did you receive a copy of the claim of lien he alleges that he recorded on the property?
No, I did not.
Did you receive a copy of the Wayne County Circuit Court litigation?
No, I did not.
Were you surprised to find out that you were being sued in the 36th District Court for a balance that you had to sue?
I was in shock, yes. I wasn't aware until somebody sent me a solicitation saying you're being sued. Like a random person, I don't know, an attorney's office. That's the first I heard.
You work. Regarding the work that Streamline did, they called in actual governmental inspections of the municipality.
Yes, we did several.
And ultimately, it was final out receiving green sticker approval.
Correct.
Did you ever see a green sticker approval for any of the work that Luminary done on the project?
No.
Earlier today, he testified that he got one for the limited scope of work that he did, and despite it not being on a signature records. Did you see that sticker in your house?
I called, I pressed Mr. Cooley on several occasions saying that supposedly, because I wasn't even 100% clear that they were actually, because I wasn't even clear that.
This goes beyond the scope of work.
I'm not asking you to tell me what Mr. Cooley said, but when you had a conversation with him on October 13th, 2023, did you learn that an inspection had never been taken place on the property?
Correct.
Did he ever tell you that, in any other conversation, that an approval was being issued to Luminary for the limited work? Through your conversation with Streamline, did you learn that there had ever been an approval issued for any work? And then ultimately, you paid roughly $20,000 to streamline the scope.
You weren't in front of me this time.
Thank you. Were you living in the house at the time Luminaire was working in the house? You were living somewhere else in Michigan, Michigan. Okay. And then let's get to the real crux. Somebody hit you up for a bribe.
Sorry.
Somebody asked you for a bribe to pay cash for a ooh, is that right?
That's.
Did you go to police? Did you go to Cooley?
So I wasn't interested.
Quite egregious.
I don't know.
Have you gone to the police since?
No, but maybe it should.
Or Cooley? Do you have any proof other than your verbal? Now, the text that you have has attached to it a sticker, or excuse me, it has a one-page attention Damian Jackson, right? And it's dated October 6th. So on October 6th, when you got this text, that was still a few days before Luminaire said they're going to not work on your house anymore.
It was October 8th on Sunday. Harold was there on the 6th. Harold Powell was there on the 6th, and I made the determination on 2 days after receiving that I was no longer going to do business with him.
So you fired them, they didn't fire you.
Correct.
Still in all, on October 11th, regardless of who fired who, why didn't you say somebody hit me up for a cash bribe on October 8th? Why didn't you say it to Luminaire?
Well, he's the person that did it.
Why didn't you say it to anybody in writing? Ever?
I guess I could have.
No, the check that you paid, was that drawn on Ayala Group?
That's when.
What do you think? Yeah. You say you micromanaged the job. Is that, did you notice that Streamline went to a flat rate billing when Luminaire had been hourly? Did you notice that? Did you tell Streamline that despite the last contract?
Yeah.
Oh, yes, sorry.
Yes, can she thank you?
Yes.
So did Streamline know that you were having a fight with the previous electrical Luminaire at the time Streamline?
Yes, they did. They were fully aware of that. That's why they put me in contact with this school. That's why we got on a 3-way conference call to talk about the issues.
Might that also be why Streamline billed it on a flat rate basis, line item as opposed to hourly?
I don't know what their own practices are outside of what they do.
So you were paying Luminaire hourly, and the original estimate had 80 hours built into it. And you told, I think it was Jacob, hey, I want those hours back when you go to court now. Right?
All right, speak up now.
Say yes or no.
Yes, and oh, yes.
What difference does it make if you get the 80 hours from Luminaire at some point? What difference does it make if it's today or tomorrow?
Because they were only scheduled to be there for 2 weeks. So I did not want to have happen.
And were you surprised when you got this text and attached to it was this page, attention Damian Jackson, and has all these items listing maybe an electrical code, building code. Were you shocked when you got this?
It didn't look like it was from the city. That's what shocked
So
me.
who do you think typed it up?
Somebody looked in there.
Do you think Luminary would have misspelled the name of their own company?
Awesome.
So Luminaire, which starts with an LU, They might have started typing with ILLUM. They might have misspelled the name of their own company. Nothing further.
All right, anything on redirect?
Briefly. We were just asked if you had done anything to complain or report the inspection reports that are at issue. Is that correct? Have you taken any steps to bring to the attention of the state of Michigan, the electrical inspection provided by Luminaire? Have you filed any complaints against the electrical license? Yes. And as part of the basis of your complaint, you brought to the attention of Laura, the licensing board for the state of Michigan, that you were given questionable inspections from Luminaire. And you made that complaint and report to them because you felt that you were wrong by the electrical contractor.
I have a couple questions. One, and I directed to the attorneys, I'll say, have an opportunity to object. You did not, ma'am, you did not keep a diary or a list with any kind of documentation of the number of hours spent at the job site. Is that correct?
No, I was present, but I did not, I just know that when they were not there, I reach out and say, no one's here.
But you never kept any diary documentation, anything along those lines, correct? Right. There were times when, if I understand this correctly, based on some of the testimony I heard, there were times when Luminaire was there when you were not there or when you were out of town. Is that correct?
Maybe on one occasion.
And so you said maybe on one occasion, you're not sure if it was one occasion or something more than one occasion. Correct?
I have text messages that show just one occasion I wasn't there. And that was near you. They were trying to get access to the place, but I was not there.
So other than that one occasion, you're saying that the Luminaire would not have had the ability to get access to the property if you weren't there?
I had a lockbox. Okay, so I had a lockbox up until when I got that inspection that I questioned, that I didn't take it, I changed the lockbox. And so they could not get access to the property.
Were there, before changing access to the lockbox, were they able to access the lockbox to the property? Before that time? Yes,
but I was there and I had an alarm system, so they had to notify me when they were coming, so I could switch the alarm on.
All right, that's it for me. Any inquiry based on the court's.
Oh, Your Honor.
Only one follow. In addition to the alarm system, you have a camera system as well.
Correct.
Never issued testimony.
Okay. And through the camera system, you could see if vehicles were there.
Yes, and I regularly routinely monitor our camera systems.
And you paid them for the 80 hours, is that correct?
Correct.
All right, thank you. Unless there are other questions, you may step down at this time. Counsel, anything further defense?
Nothing further defense rest.
Oh, Your Honor.
Any issues that way? No.
Oh, Your Honor.
All right. You ready for argument at this time, sir?
Ready, Your Honor.
All right, you may proceed at this time.
Your Honor, brief closing. We had a homeowner on a large scale home, admittedly micromanaging the job. And yet she didn't get a licensed general contractor the first time out. She didn't check the cameras in the home when she said that Luminaire contractors were not on site. She didn't keep a daily log. She paid 16,000 and some in January of 2024. And Luminaire just wants to get paid, as the court heard testimony of Damian Jackson, in the amount of $5,912.
You may extend.
One correction, the original contractor was licensed, they just elected not to pull permits. But from the defendant's standpoint, the plaintiff has been compensated more than a fair share for the work performed, given the fact that he was ultimately removed from the project for the unofficial inspections that were reportedly fraudulent on her to create additional work on the property, and then subsequently had to bring Streamline Electric in, and she expended over $20,000 correcting the work. Therefore, her damages exceed, and in addition to the $16,000 she paid them, the $20,000 she paid on the finish, she's greatly exceeded any estimate that was ever provided to her by Luminaire. And the argument is that they've made the first material breach with the questionable inspections, not properly finishing the work, and that the balance was disputed anyways. Therefore, there's no additional money there.
Thank you. Last words is to you, Council.
No, Your Honor.
Just. All right, the court has listened to the testimony offered in this matter, and the court does find that based upon the testimony and the stipulations that are set forth by the parties, that the parties did in fact enter into a contractual relationship for electrical services to be supplied to a home at 18065 Hamilton Road. While that agreement seemed to have commenced in June of 2023, the testimony is that the actual performance of service started at a time subsequent to that. Moreover, the testimony establishes that in October of 2023, the parties, by way of disagreement, decided to part ways. The plaintiff in this matter indicated that they were having some differences and decided that they did not want to go further, and that they ceased from work and ultimately sent a bill to culminate all things. The testimony of the defendant in this matter is that she became frustrated by the reality that she had not received evidence to her satisfaction regarding whether or not the property was properly being inspected, and as a result of that, and having had a bad experience with the company prior to Luminaire, she decided to terminate the services, and that she would go and deal with another company. Either way, the parties mutually agreed to go their separate ways. What was left there is the contract that existed between the parties, and what obligations are under the contract, and perhaps under principles that might be argued quantum merit recovery in the sense of reasonable value services performed. In this particular case, the contract really speaks volumes as to what is to occur regarding the outcome of this case. And I looked at the document that is set forth as the contractual relationship between the parties, which is dated the 23rd of June of 2023. It calls for electrical services throughout the home with an outcome of $18,062.85. I looked very carefully at that contractual document to determine the process that the parties embarked upon or engaged that would identify what would occur in the event that there were overages. I looked at the portion where it says that of course this is an estimate, and then it talks about that under services, it says electrical materials will be additional pricing where needed. It says where needed, but I presume that means where needed. We will finish using existing materials for previous contractors. That's on Exhibit A under the part that says services. And I will note as I look at that, the $1,400 that is set forth there is not an amount that is set forth simply for a permit, but it speaks to the use of various materials, electrical materials as needed, as part of the pricing there. What is miserably lacking from this contractual document is any statement of any process by which additional work would be compensated. I would think that something of that nature would be included in the preliminary contract. Moreover, that to the extent that there are changes that occur along the way, that there will be documents issued relative to a sign-off for additional work as that work is performed. That is consistent with the standard of practice as it relates to providing services of this nature. Certainly, it could be, it should be in a reasonable contemplation of the parties involved that when you're talking about coming into a property where there are walls that are already up. This was not a situation where the walls were open except as some testimony provided in their attic area and in the basement area. But throughout the walls had been covered. The electrical had been already covered without inspection. I had nothing covered. So it is not unreasonable to expect that in the performance of services that were being made by Luminaire, that Luminaire would discover along the way other work that might need to be done, and that they would invoice that, or that they would provide some type of documentation that this additional work is needing to be done, so we need to sign off on additional work. None of that is a part of the relationship, and yet there is a final billing, if you will, that is essentially a billing that exists outside of the contract and or outside of the contractual process. I understand that the testimony makes it clear that this relationship did not end up like all of the family. I mean, this ended up with the parties coming to an abrupt conclusion that whether he fired her or she fired him, or they fired them, it doesn't really matter. But the reality of it is that it is what it is, that there was a separation. Well, the reason that you have language that addresses additions and changes is because of the reality that a divorce might occur. I use divorce loosely here. And so you want language that kind of captures what happens in that kind of event. And so really the testimony here from Luminaire, from the president, from the witness here leaves a lot of holes in the sense that it does not provide a process for determining what happens outside of the contract. The second thing that the testimony does not provide, it does not provide a determination of what under the contract did not occur. We don't know. So what does that mean? That means that the contract is the contract is the contract. It is what it is. No process the parties went through appropriately, even at the end of the contract, to establish that there are amounts under this contractual agreement that were not a part of the defendant's obligation. While there is a streamline that comes in and at some point determines that the job has to be done a different way, there's an inspector that comes in and inspections are done throughout, and a whole other price structure is established. That doesn't have anything really to do with the relationship between these parties, unfortunately. Probably got started with this without all of the due diligence, and when I say that, on both sides, in terms of what happens if the inevitable happens, what happens if the parties have to go their separate ways, how do we reasonably determine what work is to be done. Even as I look at this, essentially a one-page estimate that the court has to treat as a contract in this matter, because that's where the parties launch, and that's where the work commences. That contract is what it is. It calls for $18,062.85. That's what it calls for. I don't know why there's a determination, a decision to make a check for $16,373.02. Nor do I know why there would be a claim for $5,000, et cetera, et cetera, et cetera. There's nowhere in this case that any of that is captured by the nature and the extent of the parties' relationship. For that reason, the courts, the judgment of this court will be for the contract that the parties entered into. I might add that there was no counterclaim that was brought in this matter. So the court does not consider this on the nature of a counterclaim, because there's not a counterclaim, nor is there a sufficient claim that has been raised before this court arguing for offsets or settlements. There's just not anything sufficiently showing offsets or settlements. There may be some. They're not established in this case. They're just not shown. So that when the parties walk away, they walk away on the basis of what their contractual relationship is, unless they have a sign off saying that this is not complete, that is complete, and so on and so forth. If they don't have a mutual signing off, then I'm left with the contract. What's proven here is that the parties had a contract, that performance was done under the contract. How much, what extent, I can't really be sure. So how am I to split this contract up when I can't be sure what work was or was not done? The defendant decides to walk away, the plaintiff decides to walk away, and what they're left with is the contract. And because of that, this court will enforce the parties' agreement in this matter. That agreement calls for $18,062.85. Whatever has been paid, less than that has to be paid. Whatever is argued for more than that is not established on this record. There's no process for it, nothing in the contract allows for it. There was no, nothing along the way that established that established additional sign offs for additional work that might be done. This is nothing there, and I can't make that up. The contract is what the contract is. That's where the parties are left. They're left to their agreement. I'm enforcing that. That would be my order in this case, right? That is the order for counsel.
Your Honor, I'd be willing to offer him a check today for that balance of 2,000.
I don't know what it is.
2,106. Well, I was going to say I'd offer it to him as a check in exchange for dismissal today in lieu of judgment. So what was the case for you?
Sure, whichever way you want to do it, obviously plaintiff would be entitled to, they would be entitled to their costs in this matter as much as they prevail, and would be entitled to a statutory trial attorney fee. I think it's $150. So if you work out those logistics, and I'm not trying to up it on anybody in any kind of way. You know, that arguably means you guys, yes, as a judge, you know, I work with this bandwidth, and then I work with this elasticity that's so ever so tight. And that is that I know that there was a circuit court matter that was filed. It was some type of lien that was filed on the house. Arguably, the cost of those things are recoverable by the plaintiff. But again, I leave it where it is. If I'm not going to enter a judgment, then I won't enter a judgment. You guys talk about where the court has made it good, whatever number you come up with, that solves the case. I'm just telling you what the bandwidth is because, well, maybe I've been doing this too long. It is what it is, all right? That is my determination in this matter. And I'll take a few moments so you all to decide what you want to do. And whatever you do, that will resolve the case for you. If not, I'll enter a judgment based upon the various factors that I've told you. All right, thank you.
Thank you, Ron. Thank you for the court's time.
Oh, absolutely.
Turn off the speaker. Judge,
I'm sorry.
turn off the speaker.
Yeah, that's what it is.
What's the amount?
Slow down.
2156. No,
22.56. Your Honor. We've agreed on a number. I've handed them a check. The civil judgment form allows for dismissal with prejudice without a number. So that's what we're presenting to you.
All right, very well. So the parties mutually submitted to the court a civil judgment dismissal with prejudice. And so on the record, you stipulate to the entry of the same at this time, counsel.
Yes, Your Honor.
Yes, Your Honor.
Thank you and good day to both sides.
Shall we retrieve our exhibits? Already retrieved.
Well, yeah, get your exhibits back. We'll 21-day wait on this.
What's happening, Your Honor? You know, I know. That's the next step. Yeah.
Thanks, Penny.
I know where to find. Wow.
Okay.
On the record.
So we put in a judgment, oh, we're dismissing on the judgment.
Yeah.
Okay. Hey, Steve, you can come on back over if you have a chance before you go to lunch. He's done. Oh, I mean, it's up to you. If you want to come over and do it, or however you want to do it. But they're going, he's done. I'm in the courtroom. Yeah, so you can come across if you want.
Let me see if I can just get it to work.
Okay. Huh? Oh, yeah, okay, all right.
Hey.